Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. The California Appellate Law Podcast is a resource for trial attorneys and appellate attorneys. Both Jeff and I are appellate specialists, and we split our practices about evenly between trial and appellate courts. We try to make this podcast a resource for trial and appellate attorneys so they can learn some news and tips they can use in their practice.
And a quick thank you to our sponsor. Our podcast is sponsored by CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse the service. Listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
All right, Jeff. Well, we don't have a guest today, but our listeners should not tune out because we have some cases that they must know about in their practice. Very important cases. For personal injury attorneys, we're going to talk about a crossover civil and criminal case dealing with victims' rights to restitution. We're going to talk about a case dealing with the harassment exception to free speech. We're going to talk about this one is an important one to bookmark, dealing with Zoom trials and how trial attorneys and judges need to know that these are not necessarily substitute for real trials, not at least until the legislature acts. We're going to talk about dismissals of appeals and the pitfalls that await, and similar pitfalls concerning the Rule 8.108 extensions of the time to appeal, how they work and how they don't work. So, Jeff, you want to start us off talking about this criminal and civil crossover case? I thought that was real interesting.
Yeah, we don't do much criminal case or many criminal cases here. This was an interesting one arising from the second district, People versus Nonaka. And it's a published decision. And this case had a crossover between a civil and a criminal case involving a DUI, an accident that occurred during a DUI. And it's interesting because of the crossover, and it's the rare case of a DA appealing a decision.
Yeah, you don't see that much. The defendants are usually the ones on appeal, not the DA.
Yeah, exactly. So in this case, a criminal defendant was accused of DUI in a criminal proceeding. He was also sued in a civil court for injuries to victims from a car crash while driving under the influence. In the criminal case, he pled guilty, and he agreed to a restitution hearing that would be held at some point later to determine the exact amount of restitution. So he promised as part of his plea bargain he would pay restitution, but the amount was going to be determined later. After the plea bargain, there's a civil settlement where insurance company pays the victims and the victims sign releases of the defendant.
Okay, so there's a plea on the DUI, and the victim gets paid, and the defendant is released from civil liability. So far, so good.
Yeah, case closed, right? Well, not so fast. And so back in the criminal court, the DA was seeking restitution for the victim. And the criminal defense lawyer says, not so fast. We have a signed release by the victims. The trial court denies the restitution motion on the basis of the release, and the DA appeals.
Yeah, so that seems like the right result, that the restitution has been waived away by that civil release.
Yeah, well, yeah, until the second district pointed out that neither the people nor the state of California, or excuse me, the people nor the DA was a party to the civil case, not bound by the waiver. And I found this interesting. I didn't know that the right to restitution for a victim of a crime is considered a constitutional right under our state constitution. The court wrote that restitution is constitutionally required, quote, in every case in which a victim has suffered economic loss as a result of the defendant's conduct, close quote, regardless of the sentence or disposition imposed. I found that interesting. So most of the time when I've had civil and criminal cases cross over, it's my experience that the civil cases stayed until the criminal case is completed, and then you prosecute the civil case. But I suppose if there's any lesson to be derived from this case, it's that if you're a civil attorney representing a client with pending criminal case proceedings with potential for restitution, wait until the criminal case is fully and finally resolved, including the amount of restitution, before attempting to conclude a settlement on the civil side.
Right. That would be one way to do it. I wondered if another way to do it might be if the civil attorneys had incorporated into the settlement agreement and release a waiver of the right of restitution. Is that right of restitution the constitutional right? I assume that's held by the victim, right?
Yeah, interesting. It seems to me from my reading of the case that it was the absence of the DA or the people of the state of California as a party to either the settlement agreement or the civil case that was the key issue here, not whether or not the release was broad enough to encompass restitution in a criminal case.
Yeah, it seems strange to me that why would it matter if the DA is not a party to that settlement if the restitution right is held by the victim?
Yeah.
Anyway, yeah, maybe you're right. Maybe that's the only way you can do it, is to make sure is to wait to settle the civil claims until after the restitution order has been issued.
Yeah, or get the DA to buy in and maybe
get the DA involved, sign off on the settlement, right?
Yeah. Another interesting case, this one arising from the first district, involves the use of subpoenas to identify anonymous speakers and a unique California law that protects anonymous speech. Tim, the decision here we're going to talk about begins with this language. The purpose of litigation is to resolve participants' disputes, not compensate participating attorneys. Our courts are sufficiently burdened without combat kept alive solely for attorneys' fees. Never a good sign for the appellant when the case begins that way.
No, not a good sign. Although, as the attorneys who have to live off the fees, as a practical matter, you note that often it's the attorney's fees that become the tail wagging the dog, especially when you're not dealing with astronomical amounts of damages. But when litigation proceeds, the amount of attorney's fees becomes comparatively astronomical. So I don't know, it struck me as maybe not entirely fair. At least I didn't like the idea of the Court of Appeal treating attorney fees as purely mercenary.
Yeah, well, maybe the result here was less about going after attorney's fees and more about perhaps the Court of Appeal's disdain for Doe in this case.
Yeah, okay, let's hear about the circumstances of this one.
Yeah, so the Doe v. McLaughlin case was about an internet troll, we'll call him Doe, who anonymously posted on Twitter mugshots from an arrest of a person who ultimately had his arrest expunged. And Doe posted these mugshots on Twitter, but these Twitter accounts were ultimately suspended for violating Twitter's terms of service. And the arrestee actually had litigation pending outside of California in an Illinois court and sought discovery in that pending litigation to identify who Doe was and why Doe was posting these mugshots.
Okay.
And the out-of-state court issued a subpoena and letters rogatory. That's a phrase I hadn't heard in a few years.
Letters rotatory.
Yeah.
Okay.
Yeah, to the San Francisco Superior Court, basically saying, hey, San Francisco Superior Court, we've issued a subpoena here in Illinois, respect it in San Francisco. Doe retained a lawyer and moved to quash the subpoena in San Francisco and sought attorney's fees.
Yeah, I wondered at this point. So Doe is the anonymous Twitter troll, right? And
yes,
and Doe is trying to maintain his or her anonymity as well. So how did Doe file this motion to quash without identifying who Doe is?
I've seen this happen all the time. It's quite frequent when people are trying to sue for defamation of statements made, let's say, on Twitter. Or I saw a high-profile one involving Prince Harry and Meghan Markle when the paparazzi were taking photos of their baby. Their lawyers filed a Doe lawsuit and then sought subpoenas to Twitter, et cetera, to find out the identity of people who were pushing these photos for sale. And then if those subpoenas ever want to be challenged, the lawyer just files a motion to quash on behalf of Jane or John Doe.
Okay. All right. As you were.
Yeah. So the motion to quash was ultimately unnecessary due to a settlement of the arrestee's litigation in Illinois, the state where the subpoena originated from. So you would think that settlement out of Illinois would have been the end of the matter.
And I will go out on a limb and hazard that it was not the end of the matter.
It was not. John Doe continued to litigate the question of should he get attorney's fees in California for having to file a motion to quash to protect his identity. And the interesting thing I learned from this case that I didn't know before is that Code of Civil Procedure Section 1987.2 mandates an award of fees where the target of a subpoena, an anonymous speaker, files a motion to quash if that subpoena seeks personally identifying information in connection with an underlying action involving free speech rights.
So this is specifically subpoenas directed to an anonymous person?
Anonymous person in an action dealing with a free speech issue.
Okay, an anonymous person trying to protect anonymity to engage in free speech activity is entitled to attorney's fees and successfully quashing a subpoena.
Yeah.
Okay.
So I found the case interesting because I learned about that statute. The other thing, the case involves a tortured procedural history of the litigation in Illinois and the litigation in California. But to me, the most interesting part of the decision was towards the end, the analysis of whether Doe met the statutory burden of proving that the case was related to free speech and thus warranted a mandatory award of attorney's fees. And there were a lot of problems with this appeal. Doe forfeited a few arguments, but ultimately, the Court of Appeal ruled against Doe, denied him fees, and the ruling was made because the Court of Appeal held that Doe's tweets were, quote, targeted harassment, close quote, of the arrestee. They were not deserving of First Amendment protection, and therefore Doe could not prove a statutory element of the fee-shifting statute that the underlying case arose from free speech. I can't say I disagree with the result here, but I'm always concerned when a court finds a new exception or dilution of the First Amendment. And I was interested to learn that when a Doe, brings a motion to quash to protect his identity in a free speech case, that Doe must be awarded attorney's fees if he prevails.
I tend to agree with you. I'm always a little concerned about how unlawyerly the doctrine of harassment is. It can really vary from one person to another. It's a real eye of the beholder type of inquiry, and I'm uncomfortable with constitutional rights, of especially the right of free speech being conditioned on a particular judge or other finding that the free speech was harassing. But let's go back to that opening quote, Jeff. What is your takeaway now that we've covered some of the factual circumstances of the case? Do you think the court was still on the mark to note that the courts are sufficiently burdened without combat kept alive solely for attorney's fees?
Well, let me just say, on occasion, I've taken on a slap case where I represent somebody on a contingency fee, and the only way I'll ever get paid is if there's a court order of attorney's fees. And so I feel not terribly comforted by that passage from Doe v. McLaughlin.
Yeah, I agree. I don't like the idea of being I feel a little bit chased off with a stick from from seeking my attorney's fees that are otherwise invited by the statute that we learned about in this case, 1987.2.
Yeah, it's interesting. And then the last point I want to bring up today for me, before we get to your cases, is there is a case pending before the Supreme Court. I think the Supreme Court's going to decide whether or not to grant certiorari, and involves somebody who was arrested criminally for parody. He had issued some statements about a local police department and had been arrested for it. And as happens when people seek relief in the Supreme Court, a bunch of people file amicus briefs. And this week, The Onion filed an amicus brief, which was really notable for a few reasons. First of all, it was written primarily by somebody from The Onion, as opposed to a lawyer. And it's a funny read. It is itself a parody. The things that is in the brief that it says about The Onion is pretty fantastical. And it got me wondering, can an appellate lawyer sign a parody amicus brief that makes blatantly false statements of fact for purposes of comedy? It was an interesting read. What did you think about it, Tim?
Yeah, I find myself reading it thinking, well, if this was just a piece of a parody or satire that I had found online, maybe I would, I don't know that I would read the whole way through. But the fact that it was in an amicus brief filed to the Supreme Court is what made it noteworthy for me. But I noticed that part of this case, or a big part of this case, deals with qualified immunity, and there wasn't anything to do with qualified immunity doctrine in this satire brief, and I thought that was a rich vein that got left unmined. I thought they could have made a lot of satire out of qualified immunity cases. You might know, Jeff, I'm president of the Orange County Federal Society chapter. I've actually got working on a debate on the qualified immunity doctrine coming up in first quarter 2023, and so maybe when I get that lined up, because I think there's a lot of interest on both sides of the aisle about reforming that doctrine a bit. So I'm interested to see how that aspect of the case shakes out.
Yeah, for sure.
Okay, let's get on. There are a couple of cases that I noted. The first one about Zoom trials. They're not a substitute for in-person trials. So lawyers and judges by this point in here we are, late 2022. We're in fourth quarter, Jeff, 2022. We've gotten quite comfortable using remote technology to conduct legal proceedings like depositions, mediations, arbitrations, even whole trials are often conducted via Zoom or in hybrid live and Zoom type trial proceedings. But Zoom trials are not the new normal, not yet anyway, not until or unless the legislature says so. That's what the Court of Appeal held in Reese versus Superior Court. I think that's how it's pronounced, Jeff. RYCZ. That's how I'm going to pronounce it anyway. We'll put the link in the show notes. So yes, the legislature did enact a statute for remote proceedings. That statute is Code of Civil Procedure 367.75. It's implemented by Rule of Court 3.672. But that statute, the remote proceeding statute, is only temporary, and it's scheduled to sunset on July 1st, 2023. So keep that red letter date in your minds the next CMC you attend, July 1st, 2023. After that date, trial judges and litigants are not to merely assume that remote testimony will remain a valid substitute for live testimony. And maybe you knew that already. Maybe you knew about Section 367.75. But here's something from the Reese opinion that that is new, and that is, even if the remote proceeding statute does get extended, the court now holds that blanket orders of remote proceedings are not proper. So at the beginning of the case, the trial court can't just say that all the hearings, all the testimony in the case and the trial is all going to be remote. I'm not going to entertain any in-person testimony.
Wow.
Instead, each proceeding must get an individualized analysis, whether in-person testimony can be validly substituted out in favor of remote testimony.
That's just on the issue of testimony, right? A court is still free to issue a blanket order saying non-evidentiary hearings can be remote, right?
I believe that's the case. I think this case was just dealing with testimony because it's dealing with body language and all the intangibles that go along with that. Argument is just argument. Maybe your table thumping and arm waving histrionics don't have the same effect over Zoom than in person, but I think those are not cognizable. So anyway, bookmark Reese for your next CMC or hearing on a motion to continue a trial. Next case I wanted to talk about is when litigants are confronted with having to maybe dismiss an appeal. Jeff, you ever had to dismiss an appeal? Maybe you find that it's not timely, or maybe it's not taken from an appealable order.
Well, only in the context of settlement. That's the only time I've ever dismissed an appeal.
Okay. So here's the lesson, and I've been confronted with whether to do it. It gives me great heartburn about dismissing an appeal, because the natural thing you want to do is say, I'm dismissing it without prejudice. The courts don't always let you do that. So the issue here is, if you remember one thing from this case that we'll talk about, remember that when an appeal is dismissed, even if it's dismissed voluntarily, usually that dismissal is going to be with prejudice. And that's because of a statute, Code of Civil Procedure, Section 913. If you want the dismissal to be without prejudice, then the dismissal order has to expressly state without prejudice. And like I mentioned, I've had some trouble getting courts to go along with dismissing without prejudice. So here's the case in point. It's Bush versus Cardinal. It's a September 2022 case. It's not published. The order dismissing an earlier appeal of a pretrial sanctions order did not expressly state it was without prejudice. So apparently there had been a sanctions order of under $5,000. The appellant realized, oh, well, it's under $5,000, so it's not an independently appealable order. I'm going to have to wait until a final judgment. So I'll go ahead and just dismiss it. So when the appellant appealed the sanctions order later in the case, after a final judgment was entered, the respondent pounced and said, filed a motion to dismiss the appeal, citing Section 913 and arguing the previous dismissal did not expressly state it was without prejudice. And so that's a good argument under Section 913. But for every rule, there's an exception. Here, the exception is that the prior appeal was from a non-appealable order. As we mentioned, it was from a sanctions order under $5,000, and under the appealability statute 904.1, that is not independently appealable. So that meant the Court of Appeal never actually had jurisdiction over that order, so it couldn't dismiss it with prejudice. It could never have affirmed the order because it never had jurisdiction over that non-appealable order. So the motion to dismiss was denied. But on the merits, the sanctions order was still affirmed anyway. Here's my question for you, Jeff. Back to the top. If you were the appellant, or if the appellant had come to you as his attorney and asked you, should I dismiss this premature appeal that I took from a non-appealable sanctions order under $5,000, what would your counsel be? Would you say, yeah, go ahead and dismiss, it's premature, it's not appealable? I'll just tell you my concern is, what if it's a collateral order? What if it's deemed appealable as a collateral order?
Yeah, well, my first order of business would counsel the client, why the hell are we appealing and spending party and judicial resources on a sanctions order of less than $5,000? The first rule of
that's no fun, Jeff. You don't get to take the appeal.
The first rule of holes is, when you find yourself in the hole, put down the shovel. But sticking to your hypothetical and to this case, I don't know that I would ever counsel moving to dismiss the appeal, only because it's such a murky area. There are collateral order exceptions in terms of jurisdiction. And worst comes to worst is if you persisted with the appeal, you'd fight either a motion to dismiss from the opponent or perhaps a sua sponte dismissal by the Court of Appeal.
Yeah, I agree with you. When dealing with these kinds of things, there are too many exceptions to the appealability rule. I know they're jurisdictional. I put scare quotes around it because there's too many exceptions to the jurisdictional rule, and there can be differences of opinion. It's not quite the non-loyalty standard as harassment is, but it is still a little too foggy around the edges for me to go ahead and voluntarily dismiss. I'd prefer the Court of Appeal to say your appeal is dismissed as taken from a non-appealable order. Then I can take that to the bank, and if ever there's an argument later that I should have appealed from the earlier order, I can say, aha, but I did. And the Court of Appeal said, no, Dice, it's not appealable. So I can take the appeal from the final judgment. Okay, final case that I wanted to talk about. And this deals with the extension rule to file your appeal under Rules of Court 8.108. This comes up every now and then, Jeff. I hate using these extensions. I always try to avoid using them if I can help it. So here's the scenario. So you're going to say you're going to take an appeal, but you want to take a run at a motion for new trial. So here in this case, it's going to demonstrate how many things can go wrong when you rely on 8.108, the rule that extends your time to appeal when you're filing a post-judgment motion. The case is Sharma versus Toyota Motor Sales USA. It's a 4th District Court of Appeal case, not published, but has some useful lessons here. The first lesson is your new trial motion has to be quote unquote valid. Here, failing to file supporting papers arguably made the motion invalid, and an invalid motion does not give you the extension of time to file your appeal. So even though I don't think the text of 8.108 actually supports this read that you have to that it has to be that you have to file supporting papers for it to be valid. But who's going to argue that you shouldn't have to file papers to support your motion? Second lesson from the Sharma case: if a challenge to timeliness is raised, be sure to argue your right to an extension under Rule 8.108, because the appellant here failed to raise 8.108 in her brief, so the extension request was deemed forfeited. I wondered what you thought about this, Jeff. If you fail to raise the extension to the Court of Appeal under 8.108, can you really waive that? Again, we go back. Aren't these jurisdictional rules?
I think I'm on Team Black Robe here. If an appellant always has the obligation or the burden of proving that they filed a notice of appeal, that the notice of appeal was timely, and any extensions, I think it's just a logical extension of the appellate's burden here. So I think I'm okay with this approach.
You're okay with the approach? I think I obviously it's your professional responsibility to raise all the arguments that support your case. I just feel that it's if the timelines are jurisdictional, then the extensions are jurisdictional also. I just have a hard time buying that you can waive or forfeit these jurisdictional extensions.
Let me ask you this: in an appellant's opening brief, if you don't say when you filed your notice of appeal, or you don't say when the clerk served notice of entry of judgment or the order, should you be allowed to proceed, or can the court just say, "Man, you forfeited the issue"?
Well, you have violated the briefing rules in some of your arguments. There are other sanctions for that, but I don't think the sanction is that the court denies itself its own jurisdiction over your case.
I don't think it's ever likely that a court of appeal would dismiss a case solely on those grounds. But if there were lots of issues with the case and it was messy, or the court of appeal didn't like the particular facts of the case, I could see them taking the easy way out and saying, "Yeah, we don't know if it was a timely notice of appeal."
Okay. The third lesson from the Sharma case is if the trial court takes your motion off calendar, this is a motion for new trial. Remember, if the court takes the motion off calendar, you should probably assume that it's been denied. So that's what the court did here. It took the motion for new trial off calendar because, remember, the moving party did not file the supporting papers to the brief. But instead of denying the motion, the court said, okay, well, there's no papers, not enough. The supporting papers haven't been filed. I'm taking the hearing off calendar. Does that mean that your motion is denied? The Court of Appeal said the appellant should have inferred that it was denied. Jeff, this too bothers me because under Rule 8.108, the extension begins running from the service of the order, quote, denying the motion, not from when you should assume or infer that it's been denied, but from when there's the order denying the motion. I don't know. What do you think about that?
Yeah, this reminds me of the case where somebody tried to file a notice of appeal and there was an electronic glitch. And the question is when he took reasonable steps to address the issue. And you just don't know. There's a black hole in terms of when the Court of Appeal or the Superior Court will stamp your notice of appeal. This is like that. You're supposed to take the burden of dealing with the black hole. And I don't like that rule.
Right. The black hole rule. Yeah, all ambiguities are construed against you. You must act diligently. That is a good practical rule, even if it's not really supported by the jurisdictional doctrines. I think that is a very good practical rule that when you're the appellant, you must be diligent.
Yeah.
All right, we had just I think just one tidbit that I also wanted to cover, and this was the Supreme Court. Supreme Court's comment. This is the Chief Justice comment in a concurrence on this case that said that Court of Appeal case that said that bees are fish for purposes of the California Endangered Species Act. So in a bizarre ruling earlier this year, the Court of Appeal held that bumblebees are fish for purposes of the California Endangered Species Act. The California Supreme Court was asked to review the result, and the Supreme Court denied review. But the Supreme Court does not want you to think that that means it agrees that bumblebees are fish, or vice versa. The Chief Justice specially concurred in the denial of review to explain that denials of review are perfectly enigmatic. It could mean the court thinks that the result was bunk, or that it was brilliant, or that it has no opinion whatsoever. So don't read anything into it, Jeff. Denials of petitions for review mean nothing.
Got it. So bees are fish.
And that was the upshot. I think there was an LA Times article that took that exact upshot. Supreme Court holds that affirms that bees are fish.
Yeah. All right, Tim. I think that wraps up this episode. Again, we want to thank Casetext for sponsoring the podcast. Each week we include links to the cases, including cases that talk about bees and fish that we discuss using, and listeners of the podcast can find a 25% discount available to them if they sign up at casetext.com/CALP. That's casetext.com/kelp.
And we love hearing from our listeners. If they have any suggestions for guests or topics that we should cover on the podcast, please email us at info@calpodcast.com, info@calpodcast.com. And in our upcoming episodes, you can look for more trial tips and cases you can use in your practice.
Yep. See you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.